For many people, super will be their largest, if not their only, significant asset. Instead, regardless of whether a person is a member of a self-managed superannuation fund or indeed a member of an industry fund, the superannuation savings of a member become payable as a death benefit as soon as they pass away. And the trustee of the relevant superannuation fund must either determine how to distribute those assets or alternatively follow a valid, binding death benefit nomination. There are a series of complex rules both in relation to the superannuation law and indeed under the tax laws about how superannuation benefits can in fact be paid, and then the tax consequences of those payments. Subject to specifically considering the relevant legislation in this regard, it's generally the case that superannuation benefits can only be paid to the legal personal representative of the deceased, which will normally result in the assets being distributed in accordance with their will, or alternatively, for the assets to be distributed directly to a category of person that's defined under the law as a dependent. Again, there are really specific rules around who in fact is a dependent of a deceased member, and normally the range of people will only be the direct family members, such as a spouse or children. While a binding nomination can be appropriate in many situations, specialist advice should always be obtained before implementing one. This is particularly so because in recent times there have been countless court cases where an inappropriate attempted use of a binding nomination has actually caused really significant financial detriment to the estate following a member's death.